I want to be read. Statement has been read. The question also withdraw. Dismissal. Withdraw. Okay. You said you will not be here.
My lords, but some things are not in our control.
Lord, I am also in 34.
Okay. States SLP is not listed.
What is the matter you tell us?
It's been 5 minutes back and
What is the matter? Time again, friend will allow me. My lord is asking me a question. I am only replying. The matter, this 34, along with very many matters, were listed before the vacation, before the bench of Justice Venkramna. Thereafter, some matters were not listed. It was directed to be listed on the last day, 17. 17, the matters did not come up. Now they were shown for the 8th of July. All these matters before. Now, we are not bench hunting, or we are not saying that it should go to a particular bench. All that we are saying is that my friend as a read petitioner caveator circulated a letter that there is an urgency in the matter. I mean, in that respect, registry listed the matter. Most people are not here because there are several matters together, and the state's SLP is not listed. All that, I am willing to go ahead and answer one question. Yes.
Matter has already been decided by us.
Quite so.
First listen to what we have done. These are the matters where the question was that for primary school teacher, that is for class 1 to class 5, whether diploma is the qualification or B.Ed is the qualification. We have held in a debate that diploma is the qualification. Matter finished. Now applications started pouring in, like it does in these cases, and some of them said that look, although we are B.Ed and we are not qualified by this judgment, but since we have already been appointed in a duly selected process prior to the date of this judgment, please protect us. Purely on that humanitarian ground of some interest of justice, we said, all right, the judgment is on 11th of August 2023. If you have been appointed, mark the word appointed, and we made it very clear, not selected, nothing, then this will not affect them.
So,
All of you are the ones who have not been appointed prior to that date. You were appointed post 11/8/20.
Quite so. That's correct. But let me put it in a slightly different perspective for your lordship to consider. Only to consider, which is important. Your lordship judgment in Devesh Sharma did not consider the co-equal bench judgment of Ram Sharan Maurya. Ram Sharan Maurya, this very notification was upheld and appointments allowed in the state of UP. Number one. Number two, here, they the rule and brought in a 2019 rule. It was not only the notification which my lords have been pleased to quash in the judgment of your lordships of 11th of August of the NTC, National Council for Technical Education. That notification of 28/6/2018 is what your lordship quashed, saying that B.Ed will not
quash the notification of central government.
That's what I am saying. Here, what has the state government has done, the High Court has done today, is quashed the rule which was amended in state of Chhattisgarh, which is the 2019 rule. Yes. So,
subsequent to that notification, the notification goes, the rule goes.
But the
Only to add, Rajasthan petition was reversed.
In your lordship judgment in Devesh Sharma in the penultimate paragraph is, it is only from the date of the quashing of the rule, if it exists, that the judgment will take effect. Your lordship saying Devesh Sharma in the penultimate paragraph, which I can show just now.
Yeah, read it.
Yes, sir. Your lordship may kindly have volume 2 in the first matter.
Just read it.
Yes, sir. I will read it.
Because, by the way, I will point out that in Ram Sharan Maurya, the challenge to the notification.
I wonder why my friend is a little anxious.
We have stopped wondering. You may wonder. But the argument is not in.
So, what your lordship says, having made the above determination.
Oh, this is page number?
Page number 564. And the judgment starts from page 520 in volume 2 at 564.
volume 2?
Volume 2 of the paper book in the first matter.
No,
Naveen Kumar.
Page कौन सा है?
SLP volume 2.
Page Mr. Ranjit Kumar.
564 minute.
no, the
अरे ये
Your Lordships have 34.34 in the main matter, Naveen Kumar.
yes, they have the very much.
which one you want to do?
Road number.
The exercise? Yeah, we have got it. We have got it.
Yes, yes.
Your Lordship, the court. Having made the above determination, my Lord got that. We are all the same are also of the considered opinion that the state of Rajasthan was clearly in error in not calling for applications from B.Ed qualified candidates for the reason that till the time when such an advertisement was issued by the Rajasthan government, B.Ed candidates were included as eligible candidates as per the statutory notification of NCT, which was binding on the Rajasthan government till it was declared illegal or unconstitutional by the court. The Rajasthan High Court had rightly observed they are of the opinion that the state government could not have ignored the notification while inviting applications for so and so, even if the state government was of opinion that such notification was
How does it help you? This is the legal
the
position.
sixth para thereafter. What the Rajasthan High Court had stated above is settled legal position in a recent three-judge bench of judgment of this court in state of Manipur. This position that a statute competent legislature is valid till it is declared unconstitutional by a court of law as
Now it has been declared.
Now,
By this court it has been declared.
2009,
Mr. Ranjit Kumar, no, no.
2019 rule was not declared.
कहते रहो आप जोर से आवाज से बोलने से थोड़ी आपका मुकदमा बुलंद हो जाएगा हाँ you don't need it we need it
But my lord, if the mic is off, we start hearing.
what happens Mr. Ranjit Kumar is Mr. Ranjit Kumar what happens is what we have said is the settled legal position if there is a law you cannot ignore the law. If the rule is also law, if the rule says B.Ed is qualified, you have to call him. The authority cannot say we will not do it. Till it is set aside by the High Court or the Supreme Court. That's what we have said. Now, to answer your question. By our judgment dated 11th August 2023, it has been set aside. If not so, by implication it has been set aside. You join issues. All right, madam, he's got a slight legal point. Let's finish it off.
My lords, I can argue.
Let's, I wish to say something.
I also wish to say something, my lord. First, I wish to
With
say.
great respect, my lord, I wish to say something.
May I?
I wish to make submission, my lords.
Only-
My lords, I appeared in the High Court, my lord, so please allow me,
To that sentiment,
please allow me to make
right?
submission, my lord.
My lords,
Ma'am, before,
can I make a submission here on
my lords,
that?
before my learned friend begins, my lords, may I say something? May I say something, my lords?
Mr. Srivastava, Mr. Srivastava, hold on. We'll hear.
Just 1 minute.
Not even I may be heard for 5 minutes, not after him. I have to talk.
I have something important to inform your lordship.
The notification of 28th of June 2018. So they did not allow the B.Ed candidates to participate. That came to be challenged before the High Court. Now the High Court did strike down the 28 June 2018 notification, but it held that the state was not correct in its conduct to restrain the B.Ed candidates to participate in the exam till such time as it had been quashed. So that is that observation of the High Court which my lord said is the correct view that has been taken by the High Court. A state cannot go contrary to the GO which has been issued by the central government, which applies across board.
Ranjit Kumar knows all this.
I am very sure, my lord.
Ranjit Kumar, is it your case that your appointments were prior to this judgment 11th August 2020?
No.
No.
Then may I say now,
How
my lords, may
in this?
I say something, my lords, now? May I, my lords? I hope I am audible, my lords.
How much time will you take?
My lords, a couple of minutes, my lords, because I have to get the background. I appeared in the High Court in the repetition, my lords, along, Madam Arora was on the other side, I was on the other side. My lords? My lords,
I can answer in 2 lines, in 1 sentence. My lords, my learned friend may just allow me for a minute. In Ramsar Maurya,
Time to warm up.
28-6 was never a challenge.
5 minutes is not enough for you for even warming up.
My lord, are we audible, my lord? In fact, we also want to assist your lordship.
We'll fix a date, then we
this
there.
is a matter which requires serious consideration.
My lord, we also want to assist your lordship.
अब जब गलती हो ही गई है,
My lords, गलती तो बिल्कुल नहीं है, यहाँ गलती बनाई जा रही है. There is no गलती there at
My
all.
lord, my learned friend is on caveat and she is arguing.
Hearing, my lords.
There is no
oh,
creative.
this is गलती, quote unquote, I'm not saying.
There is a
That's right.
situation, maybe
That's right.
he has
This requires hearing, my lords. This requires hearing. With greatest respect, my lords, and with all humility, I am submitting.
You're the Advocate General.
The state has also filed a special petition.
Ah.
And my lord, the facts are required to be told, my lord. Once the facts are told, your lordships will probably think that the matter is different, my lord, stand for a different footing.
Why don't you file a curative petition then?
No, my lord, the review is still pending before your lordships, my lord. The review has not been decided. Your lordships have been yes, the review is still pending. Your lordships can check from the website. The substantive review petition is still pending.
Then we dispose of all this petition and say you are at liberty to file a review or curative.
No, my lord, this is a special petition against the judgment of the High Court.
My lord,
My lord, this is not an IA. Oh, please, madam, please, it's important for me. This is not an IA.
Considered by my lord on it. My lord, I just want to point out one more
This is
thing.
not an IA.
My lord,
This is
in
not
the
an
order
IA, my
of
lord.
8th of April, if my lord take page number
If
651.
I'm making submission, please allow me to make submission. My lords, this is a substantive special petition against a judgment of the High Court of Chhattisgarh, which was filed by the clients of Mrs. Arora, and on the basis of Devesh Sharma judgment, this petition has been allowed, our appointments have been quashed.
My lord,
So, my lord,
one submission here at this stage.
please, my lord,